Should should we back out and wait for a different link for the guests, or is it okay to stay?
No, I think
Because
they're being added, but we haven't been joined to the larger group yet, it looks like.
Yeah,
Because
we
I
have.
see,
We're live.
oh, okay, I don't see the participants listed, so okay. Well, with that said, then I'll get started off. Welcome everybody. My name is Alex Farr. I'm with the Pro Bono Partners Committee of the Dallas Association of Young Lawyers. Thank you for everybody who's able to join today. We have the pleasure of presenting a group from Human Rights Initiative of North Texas who's going to talk a little bit about taking a case with HRI. For those of you who have not had the opportunity to work with HRI before, it's a great organization, very well respected in the DFW community, focusing on a lot of immigration issues. So very, very pleased to have them today. Just a little procedural point. They will be sharing a link at some point towards the end, or maybe we'll drop it in a chat box, Evelina, to do a direct sign up if you want to go ahead and proceed to take a case with HRI following this presentation. So there will be a sign up list to do that. And then at the end of the presentation, I will read out the CLE code so you can get CLE credit for this. But without further ado, I will hand it off to Catherine and Evelina to introduce themselves and get going with the presentation.
All right. Thank you so much for the introduction, Alex. Apologies if my voice gets a little stuffy. I'm a little under the weather, but we're gonna power through. So good afternoon, everyone. As Alex mentioned, my name is Evelina Renee Butte. I'm a staff attorney here at HRI, and I've been with the organization for almost 2 years. As far as a little bit about my background, I've been practicing for close to 10 years, started in New York as a criminal prosecutor, and then did that for almost 8 years before switching gears. Always had a background and interest in immigration and human rights. So I switched over, moved to Texas, and now I am with HRI. Love the organization, values and mission that align with mine. So I'm happy to be here and do the work that we do, and excited to tell you more about the work that we do. And hopefully you'll be interested and sign up with us as pro bono partners.
Thank you, Lina. And my name is Catherine Langlois. I started my career in Montreal, Canada, and I will not tell you how long ago because that will be older than most of you guys. And I started as a criminal defense attorney, spent most of my career working in the US as a business immigration attorney, and recently switched to family immigration and family law. And honestly, it's been the most rewarding work ever. So I'm very excited to share why and how you can catch a glimpse of that excitement. So with that, let's get it started.
All right, hopefully you all can see my screen. So we'll go ahead and get started with the presentation. And we do have a lot to cover today, so in the interest of time, we may have to skip some things, but just bear with us. Okay, so what are we going to talk about today? We want to start by going over the immigration system as a whole, and then we'll talk about how HRI's work fits into it. We'll then talk a little bit about our model at HRI, then talk about the different types of cases and clients that we serve, which are unaccompanied children, asylees, and survivors of crime. And then so that we get an ethics credit for you all, we're also going to briefly talk about some ethical considerations with our work and then discuss how you all can get involved with us.
So HRI is a legal and social services provider for immigrants who have fled human rights abuses. Our clients come from all over the world, and their stories are as unique as they are. Like, they are all different. But they have one thing in common though, and it is that they have all overcome over some devastating circumstances, and they seek the legal protection of US immigration laws. So by the number, we are a staff of 10, and we are assisted by a bank of approximately 200 pro bono attorneys. And during fiscal year 2024, we served approximately 375 clients with, which means about 700, a little bit over 700 litigations or cases for a total of 4,444 volunteer hours. So we're extremely thankful for talented volunteers such as you allowing us to serve our clients. So it may not be a mystery for all of you. Attorney representation for an immigration case is directly linked to the success of the case. So having pro bono attorneys for our clients is incredibly important. And recent data from TRAC, which is the Transactional Records Access Clearinghouse, shows that 52% of asylum seekers with attorneys are successful, compared to only 17% of the people who are not represented.
Okay. Now, pro bono cases make up the bulk of our volunteer time, but we also have volunteers who help us out in other really important ways. We've had volunteer doctors and psychologists who serve as expert witnesses for our clients. Those reports can help substantiate any physical evidence or psychological trauma left behind from what some of our clients have experienced. We've also had volunteer translators who help translate documents from various languages. And on the social services side, we've had volunteers help collect things like diapers, toothpaste, and other basic hygienic products to help our clients who are just struggling to get by. While we no longer have a dedicated social services staff, we still provide crucial assistance and necessary resources to our clients. This includes direct aid, so that's financial assistance, as well as some of the items that I just highlighted through donations. This year, we've started a partnership with Catholic Charities for a monthly mobile food pantry that's sponsored by the North Texas Food Bank. And we host that every month on the third Wednesday from 12 to 3. So just a quick plug, if anyone is looking for some sort of volunteer hours, we also welcome volunteers for that. Social services also includes referrals for things like medical care and counseling services, especially to providers who work with undocumented persons. And lastly, we also host some in-house programs like our Back to School Backpack Drive. And currently we're having our Holiday Wish event, which involves adopting a family and providing children with gifts for the holidays. So I know that some of you may actually be at some of the firms who are partnering with our organization today and have worked with us in the past.
So zooming out a little bit to give you an overview of the system, it is important to understand our cases to get some basic concepts of the immigration system. We're going to do that brief overview right now, and just before we dive into our program. So for anyone coming into the United States, the first determination that we as attorneys must make for immigration purposes is how did that person come in, or on which instrument or basis did that person enter. So most people fall into three categories. There's bulk of people that come in without inspection or legal status. So the first category is those people who have entered the US without any status, meaning they don't have a visa, they just present themselves at the border inspection point, and they do not have any kind of permission to stay in the United States. The second category, which is most people that come in, is the temporary legal status. So they do have permission to come live or work in the United States for a period of time. For example, that will be a tourist visa, H-2B worker visa, TN, all the gamut. I mean, actually, if you're curious about this, there's an alphabet soup of visas on the USCIS website where you have all the categories and subcategories. And then there's a third category of people that come in, which is very rare, but it does happen that someone can have obtain permanent legal status abroad and come in as a legal permanent resident or a citizen. So from those statuses, not everybody will have to stay in their status of arrival. So for example, a person entering with no legal status may find relief, and sometimes protection under our laws are available so that they are not subject to deportation. Certain programs, such as temporary protected status for nationals of countries experiencing extraordinary circumstances, or DACA, will allow a person to stay lawfully in the US, but will not give them a path to a more permanent legal status. Other temporary legal status, most commonly the work visas that we mentioned, will grant temporary legal status with an option to adjust to a more permanent legal status. So our goal for our clients is to obtain a more permanent status, either temporary or permanent. The majority of our clients at HRI are in the no legal status category, and our goal is to help them move to the other buckets of temporary legal status and eventually permanent status.
So unfortunately, there are multiple myths surrounding how immigrants can stay in the US. These break down into three main categories. First being that there are straightforward applications, second, that there's an easy pathway, and three, that there's an open policy for immigration. These are all false. First, for straightforward applications, the applications are only eligible for certain types of immigrants. If the immigrant is outside of these restrictive paths, they will not be eligible to apply. Next, easy pathway. It's actually very difficult to immigrate legally to the United States. Immigration law is second only to the income tax code in its legal complexity. And third, open policy. The annual inflow of immigrants to the United States as a percentage of our population is below that of most other rich countries in the Organization for Economic Cooperation and Development. So again, these are common misconceptions as far as how the immigration landscape is in the US currently, and we want to be able to dispel those myths. Most of our clients are in the United States without any legal status, either because they entered without status, like Catherine mentioned, or because they overstayed one of those temporary visas, but some do have temporary legal status. Our clients fit into three general categories. Those are people fleeing persecution, victims of crime or domestic violence, and children escaping abuse, abandonment, or neglect in their home countries by their parents. Our job is to determine whether they qualify for one of the services we provide: asylum, withholding of removal, U visas, VAWA, or special immigrant juvenile status, and then help them to gain that status. This graphic is actually a few years old, from fiscal year 21, but on average, our clients make up about 6% of the people who are able to become permanent residents each year. However, they often represent some of the most vulnerable people who are in the US seeking legal status.
So to give you a heads up on some terms that can be confusing. So refugee versus asylum. Refugee status or asylum may be granted to people who have been persecuted, as Evelina mentioned, or are afraid to be persecuted on account of race, religion, nationality, membership in a particular social group, or political opinion in their home country. So the refugee is the person who is forced to flee their country because of that fear of persecution, and who is seeking safety in another country, so here in the US. And then the asylee is the person who meets that definition of refugee and is living in the United States and granted asylum. So that is one thing. And then the EOIR, or The immigration court is the EOIR stands for Executive Office for Immigration Review. Immigration courts are civil courts, neither Article 1 or 3 courts. They are part of the Department of Justice and subject to the political influences of the executive branch. So USCIS and ICE were formed following September 11th. Before September 11th, the Immigration and Naturalization Services comprised everything related to immigration. Now it was restructured into the U.S. Citizenship and Immigration Services, USCIS, which is the administrative arm of immigration, and ICE, Custom Enforcement, which is the immigration enforcement arm for the immigration. The Department of Homeland Securities oversees those two sections along with the Customs and Border Patrol, CBP, and the Department of Justice oversees the Immigration Court and the Board of Immigration Appeal, which is overseeing the Immigration Court's decisions.
Okay, now we'd like to switch gears and talk about the HRI model and how we work, because we are in some ways a little different than other nonprofits. So HRI has two main components, our internal legal services and internal social services. First, HRI legal screens a client. We determine, is the client eligible for relief, and does the client meet our income guidelines? Secondly, HRI Legal signs a representation agreement, which is our contractual or engagement letter, if you will. Once we determine the relief that they qualify for and their income, we're ready to officially sign them up as a client. We sign a representation agreement to begin the attorney-client relationship. And third, pro bono is paired with client. Pro bono counsel represents client, supervised by HRI Legal. So in that third step, for your internal firms, there's typically an engagement letter or whatever your retainer, your contractual document is to start that attorney-client relationship. We would also have the client sign that with you when you'd have that first meeting with them. Once we sign up a client, we also consider any potential social services needs. So we want to find out, does the client have shelter, food, and clothing needs that are met? And does the client have any medical or mental health needs that need to be met? And where we can, we're able to bridge the gap, provide them with resources, provide them with any internal resources that we have on site. Today, we're going to talk through how everything works and use some examples for you. These samples are anonymized, but they are based on real client experiences. So the stories of Santiago, Florence, Maria, and the Perez family cover the four main case types that we handle. Santiago will be an example of a special immigrant juvenile or SIJ or SIJ case. You'll hear all those terms interchangeably. Florence is an example of asylum. Maria will be VAWA, and the Perez family is an example of a U visa.
So as Evelina mentioned, the Special Immigrant Juvenile Status, or SIJ, is one important way to assist our clients who are unaccompanied minors. And it is a path or a status which will confer a path to permanent residency and ultimately citizenship for those children. So so when they arrive at the southern border, children are placed into custody. They are informed of their rights and given a list of service providers. And we being one of the largest provider in the DFW areas, 90 to 95% of our clients are coming from that referral. So when they first come in, any child that comes to the border gets in touch with a Border Patrol agent will be screened within 48 hours to determine if the child is accompanied or not. If the child is not accompanied, then they will be taken care of by the Office of Refugee Resettlement, or ORR, and they will be in the custody of ORR within 72 hours of their arrest. So that means that they will be put in a less restrictive detention setting or shelter. So keep in mind that the children are still in custody until they are released to a sponsor, and the conditions of shelters vary widely. They are operated by ORR contractors, and some, like the shelter operated by Catholic Charities, are colorful, friendly, just very nice living environment, while others, which are administered by private prison companies, may feel very different. So the children will stay there until they are released to a sponsor and until ORR determines who will be the appropriate sponsor and have done the background on those individuals. So potential sponsors, who are they? Most of the time, they are close relatives who already live here. Could be immediate family members, parents, grandparents, brothers, sisters, uncles. But some of the children that we work with have one parent who's been in the US for years. And for example, that child was living with mom in home country, and then mom decided to remarry, and her new partner is abusive toward her and the child. So child goes to live with grandmother, and then sadly grandmother passes away. So there's no one available in their home country to take care of them. So the child is here to be reunited with dad, who is now the only available and capable caregiver for that child. So the vast majority of the children we represent have been released to sponsors in the DFW area.
Okay, so now we want to switch to focusing on Santiago's story, just taking into consideration what Catherine just mentioned. So Santiago lived in El Salvador with his parents. His father was an abusive alcoholic. He would take out his anger on Santiago's mom and on Santiago by beating them with electrical cords when he came home drunk. Santiago was often sick, and his father refused to bring him to see a doctor. Gangs started trying to recruit Santiago when he was 12. When he refused, they retaliated by increasing his family's rent, which his family forced Santiago to pay by working after school from 2 to 8 p.m. At 14 years old, Santiago made the difficult journey to the US on his own. So now after hearing Santiago's story, this would be something that we would find out about through sometimes a referral and then meeting with the client. We now have to determine, we being HRI legal, our lawyers and legal assistants here in the office, we're going to screen him to see if he's eligible for special immigrant juvenile status. The first question, which is an easy one, is whether he's unmarried and under 21 years old. There's nothing in the fact pattern that said he was married and he was 14, so check. But we do advise you all to make sure that the child is under 18. Otherwise, in Texas, generally, they will not fall under the family court jurisdiction. And Catherine will talk to you in a bit about why that's important. I do say generally because there are some exceptions to that rule as far as being over 18. Next, we're going to find out whether Santiago can be reunited with his parents due to, or cannot be reunited rather, due to abuse, abandonment, or neglect. Based on the facts, that should be checked off as well. Then we're going to ask whether it's in Santiago's best interest to return to El Salvador, which based on the facts, clearly it's not. And finally, the last question is whether he's currently under the jurisdiction of a juvenile court. Most of the kids we screen aren't, which is why, as we'll see in a second, special immigrant juvenile cases have a family law component before we can start actually seeking immigration relief. So this is just highlighting again those key facts that would make this stick out for us when we're screening him as a potential SIDGE case. All right, so based on what we saw and learned about Santiago, HRI decides that we're going to take his case. Again, the first thing we'll do is have Santiago and his sponsor or guardian sign a representation agreement, which is our retainer, and that establishes the attorney-client relationship. Then we'll start building his file with all of the information he brought in to us. So usually we're asking him to bring any and all immigration documents, any ID documents like birth certificates, or if they have a passport, just so we can start compiling information that's necessary and we can pass that on to you all as the pro bonos. And then we'll also compile any training and background resources that we can share with pro bonos in a pro bono packet. We also coordinate any translation of documents that he has in his native language. So again, thinking about that birth certificate, typically if they are from a majority Spanish-speaking country, that birth certificate will be in Spanish, so we'd get that translated. If we have a parent who's deceased and there's a death certificate, we want to get that translated, things of that nature. So we'll have that all prepared for you in order to build up the file before we can assign the case. And then the third step, pairing Santiago with a pro bono. So HRI would pair Santiago with a pro bono attorney. We'll talk about, hopefully we'll get to it a little later, just talking about how we go through that pairing process. And then our pro bono attorney would meet with Santiago. As I mentioned briefly before, that first meeting will take place in our office at HRI, but then subsequent meetings typically take place at the firm's offices. We do like to do that first meeting here just to build rapport, since typically the child has met with us and may feel comfortable here. And then basically we hand it off to the pro bonos and you guys take the reins from there. And the last thing I would just note, that final meeting would be with Santiago and his guardian or parent, whoever the sponsor is going to be.
So as we have mentioned, we have brushed on a little bit. The SIDG requires a two-step process. So there's a family court component, which is going to be handled here in Texas Family District Court, and an immigration part. So the family court, the first requirement that we need to even be able to start is that the child needs to obtain an order confirming our facts of abuse, abandonment, and neglect, which will need to accompany our immigration petition. So generally, to obtain that, we file a suit affecting the parent-child relationship, or SAPSR. And that SAPSR does not terminate parental rights, but it simply designates as sole managing conservator for the child here in the US. And that is because we also need that finding that it is in the best interest of the child to remain in his current placement here in the US, and reunification with one or both parents would not be viable because of abuse, abandonment, or neglect. So those factual findings are what we screen for at the beginning. So Santiago, unmarried, under 21. In our case in Texas, they need to be under 18. And to specify also the exceptions, we want to obtain that order before the child turns 18 or before he finishes schools from high school from an accredited school here in Texas. So that can give us a teeny bit of leeway when the child turns 18. But generally, we want to obtain that family court order before they turn 18, because they will no longer be under the jurisdiction of the court. So we need to include in our final order 3 important elements. So the factual findings of abuse, abandonment, and neglect that we mentioned by one or both parents. Reunification is not viable, and very importantly also, it is not in the best interest of the child to return to his previous placement or home country. So once we have that application, so once we have that order in hand, our pro bono is going to prepare Santiago's application for relief, which is the immigration component of this SIDG. So we will submit that I-360 form to USCIS, and generally it will be adjudicated without requiring an interview. But if they do require it, our pro bono will accompany the child to the interview. Also, there might be an important court date set in our pro bono, and I mean in EOIR for the child, because they arrived illegally and may have been given a court appearance date, so it is important for that child to show up at the hearing. Otherwise, they may be issued, there might be an order of removal issued in their absence. So our pro bono will also accompany the child to that hearing. So this briefly, this gives you a visual of the steps. So the first goal when helping our clients is to move our client's status from unlawful to deferred status. So we want them to be protected against removal. So second step is to get them employment authorization as soon as possible. And once they have access to some relief, our goal is to help them adjust their status to a permanent legal resident or green card status. The actual time in family court varies. It can be 3 months to 6 months to a year, but generally we can finish that kind of easily. It does not take a long time to get the I-360 application approved. Usually it is a 3 to 6 months process. And then what may take longer is, and we can apply for an employment authorization after that. However, what may take a long time is the adjustment of status, and that may take years before that is even authorized.
And just to echo what Catherine just said regarding adjustment for those kids, the priority date that's mentioned is based on a chart that USCIS issues. And actually, on that chart, it determines based on the date that they initially applied, essentially their place in line and when they would be able to apply to adjust status. So right now, as we are in 2024, the cases that are being adjudicated and are eligible to apply for adjustment are from the beginning of 2021. So that just gives you kind of a general sense of when she mentions that wait time being years, it really does take a while for that to happen. Okay, now switching gears, we want to give you a primer on how we take an asylum case at HRI. So I'll go through Florence's story. Florence is a mother from Zimbabwe who has a young daughter. She was a member of the opposition political party, Movement for Democratic Change. She helped plan events for MDC, including several protests. In 2018, the government shut down the internet and rounded up opposition political party members. Florence was detained, beaten, and interrogated for days. After she was released, she was followed by unmarked cars on several different occasions. She believed these to be government forces. Florence and her daughter were able to use visitor visas to flee to the US, where she learned about asylum through the Zimbabwean community in Dallas. So we're going to do a similar analysis for Florence. HRI generally serves people who are not detained. So we would meet Florence when she found her way to us. She might find her way through other organizations like Catholic Charities or through those referrals that we mentioned previously. So we'd set up that legal screening with her, and we'd have members from our legal team hear her story and figure out whether she'd be eligible for some relief. The first question we try to answer is whether she experienced persecution in her home country for one of the reasons that's enumerated in asylum law. Persecution for asylum law is defined as infliction of suffering or harm upon those who differ by a government or group that the government is unwilling or unable to control. Past persecution gives rise to a presumption of future persecution. So when we talk about unwilling or unable to return to Zimbabwe because of past persecution or a well-founded fear of future persecution, that has to be on the account of either her race, religion, nationality, membership in a particular social group, or her political opinion. So once we consider all of that in evaluating an asylum case, we have to determine, does Florence seem eligible for relief? And also, of course, does she meet our income guidelines?
So once we believe Florence has a claim, as Evelina said, there are various bars to asylum. So we need to make sure that Florence will not be barred from filing her application. So those bars include a safe third country, a 1-year filing deadline. So this is pretty strict. Once she comes in, she has 1 year to file her asylum application. She will not be eligible if there was her activity in persecution of others and some other criminal, national security, terrorism, or are also bars to her filing her application. So we will have screened for all of those before the case get placed with a pro bono. And because she did not, she passed our credibility screening and she did not have any bars on her fact history, we decide to take Florence's case, and just like for Santiago, we will obtain a HRI representation agreement and begin building her file for you guys to start working on. So we estimate that the pro bono work for an asylum, we estimate the pro bono work for an asylum case to be between 20 to 40 hours. The bulk of the work will be preparing the application for asylum and preparing Florence for an interview. Of course, HRI attorneys will always be available for questions and mentoring during that preparation.
I believe Catherine touched on it, credibility. We have to look at the case with a super critical eye because small inconsistencies will affect Florence's credibility. Minor inconsistencies and minor omissions support an adverse credibility finding, and we have seen that occur in some of our clients' cases before they come to us. The trier of fact may base a credibility determination on the client's demeanor or candor. They look at consistency between the applicants or a witness's written statements versus their oral statements. And they also look for internal inconsistencies between each statement. Lastly, they'll look for a lack of consistency of each statement with the rest of the record that's presented. So it's an important tip to, as you all do, I'm sure, in your regular work, make sure that you're cross-checking all documents and looking for any potential inconsistencies in an asylum case. In all cases, but especially asylum cases. One quick thing we wanted to talk about is Florence's daughter. So some family members of asylum beneficiaries can also qualify as what we call derivatives once asylum is granted. This includes spouses and unmarried children who are under the age of 21. So in Florence's case, if she were granted asylum, her daughter would also be granted derivative asylum status. And in our case, in a situation like this, we would take on both of them, or could take on both of them as clients. So Florence's case would be an example of an affirmative asylum filing based on the facts that we gave you. And we'll talk about differences in a little bit because we can file an asylum case affirmatively or defensively. Sometimes when we file affirmatively, those cases are not granted by the asylum office. This doesn't mean that the client gets immediately deported. Their case then gets referred to the immigration court. So that moves their case from the affirmative process to the defensive process. So hopefully you guys can follow along on the slide here. A person who has never come in contact with the immigration system, meaning they weren't apprehended at the border, for example. And if you recall from Florence's example, she and her daughter came in on visas, so that wouldn't have been their situation. They go through an affirmative asylum process where they themselves would file an application, go to USCIS for an interview. The application from there is either granted, in which case they would be granted asylum status, or if not, it's referred to immigration court for a defensive asylum proceeding. And then they would have that immigration court date. They would have essentially what we call an asylum trial, which is an individual merits hearing. A person, however, might go straight into immigration court if they've already come in contact with the immigration court and then removal proceedings began. In that case, the person would only ever have a defensive asylum case, not affirmative, and we handle both types of cases.
So essentially, this is just giving you a visual of what Evelina just explained. So they are two very different processes. I would say affirmative asylum is a paper-based claim, and it is positive action taken by the person seeking asylum, whereas defensive asylum, it is something that because they have been apprehended at the border, they already have an order or a possible order. They have to defend that condition. So it's a defensive asylum. It's much more like a trial. And it will also happen if you lose the affirmative asylum, but it is all in immigration court. It's much more of a litigation case, and the affirmative asylum is a transactional case, being all paper-based. So we talked about that. If Florence lost her case before the asylum officer, then she's referred to immigration court for her formal adjudication before a judge, and that becomes an asylum case. And the defensive asylum then becomes a real trial, will consist of one master calendar hearing where the person will essentially be admitting to the charges of the document, the charging document or the notice to appear, which was handed to them when they were apprehended, or which was the person will have to respond to the charges, and then there's a judge who decides whether to grant or deny the asylum. So the pro bono will prepare this entire case. That will take probably 150 plus hours because we need to put together a brief, prepare witnesses, gather all the witnesses, expert witnesses if necessary, prove country conditions, and all the documentary evidence that we will need for that trial. So the calendar hearing is called the master hearing, and then there's the individual merits hearing, which very often is scheduled years after the initial hearing. So as Evelina said, preparing the client is critical. It is really, really important because any minor inconsistencies will be a basis for rejecting a client's asylum claim. So credibility of the client is the very first threshold in any defensive asylum. And our pro bonos will represent that client in court. So it means that it is a trial-like proceeding. So some judges will allow opening statements and all of them will allow closing statements, but it is just like a trial. So direct cross-examination, but keep in mind in a immigration court, the judge is very often a participant asking questions himself. So that is different. So timeline, we talked about 150 hours, and the range can be 4 to 8 years because from that initial calendar hearing, for now, I think that the dates are in 2028 for a trial, so that would be a few years from now. And then you will require a team of 2 to 4 attorneys to do a great job on that.
All right, so once again, we have the timeline for you. For asylum clients, it can take a period of months to years for the application to be approved, in part depending upon whether you're going through that affirmative or defensive process. And there's a first in, first out rule. There's a little discrepancy right now as far as how they're actually applying the rule. But that rule was an effort to speed up processing for new asylum applicants, so that those who are most recently applying would get adjudicated first. And what we're seeing is that those older applications are taking a number of years to get adjudicated. The good news with all these years that clients are waiting for asylum cases to be adjudicated is that they can apply for work authorization. So that can come 6 months after the asylum application is on file. And so while they're here for years waiting on their cases, they are able to work legally in the US. Once the application is approved and they become asylees, there's a 1-year waiting period before clients can become green card eligible and apply for lawful or legal permanent residency, and then 4 more years until they're eligible for citizenship. All right, so that I know that we are short on time. We did want to spend the bulk of the time focusing on those first 2 case types because currently those are the main case types that we are taking at HRI. But we want to talk just briefly about our crime victims program and how to assist survivors of crime through other case types such as the U-Visa and VAWA. So VAWA is the Violence Against Women's Act, and it doesn't just apply to women, as the name may indicate. These cases are just brought under the Violence Against Women's Act of 1994, which was a federal law enacted to give crime victims a pathway to lawful status if they'd been abused by a US citizen or US lawful permanent resident who's their spouse, parent, or child over the age of 21. So quickly, just going through Maria's story. Maria was a college student from Argentina living in the US when she met Joshua, who was a US citizen. Joshua was charming and kind. They began dating, they fell in love, and then they got married. She moved into his apartment. When she became pregnant with their first child, he began drinking and acting jealous. He controlled the money she earned from her job, accused her of flirting with customers while at work, and after a particularly bad fight, Joshua hit Maria for the first time. She left their home and sought refuge at a domestic violence shelter. So this is a very typical example of a case facts that you may hear for someone who is eligible for VAWA. Maria has that qualifying relationship. She was subject to battery or extreme cruelty by her spouse, who was a US citizen, during the relationship. There is cohabitation because they live together. She showed good moral character and also entered the marriage in good faith. So we don't want anyone who appears to be in a fraudulent marriage seeking assistance under VAWA, because you will have issues there trying to establish that it was a bona fide marriage and it wasn't fraudulent in any way. Okay.
So this application for VAWA is the same form that we use for the SIJ application or the I-360 form. It will take about 30 to 40 hours for the pro bono to complete. And we will need the application, attorney representation form, the application itself, the form I-360, an affidavit establishing that relationship and the abuse, And then proof of marriage, good moral character, and abuse to be included in that petition.
Okay, just to quickly touch on U visas, this is another case option involving survivors of crime. The U non-immigrant status, commonly known as a U visa, is set aside for victims of certain crimes who have suffered mental or physical abuse and are helpful to law enforcement. So there are qualifying crimes that are defined by statute, and the statutory definition and the most common cases that we see include domestic violence, rape and sexual assault, incest, felonious assault, and murder. So we're going to skip over the example for today, but in the example from the Perez family, you'd see that the family suffered what was deemed a qualifying crime. They suffered physical or mental health because of the crime. They were helpful in investigating or prosecuting that crime. And there were humanitarian reasons that justified waiving inadmissibility based on their facts. Similarly to what you saw under asylum, also with U visas, you have derivatives who may be eligible for status as well. And again, that can include a spouse, unmarried children who are under 21, the parent of a victim if the victim is under 21, and a minor sibling of a victim under 21.
So again, we estimate between 30 and 40 hours to complete a U visa application. And that will include meetings with the family to review the documents, gather evidence, and prepare the application.
Okay. We had a comparison for you. We're going to skip over that right now and go into some ethical considerations.
So so as always, the rules of professional responsibility will apply to our work. With Rule 1.01, saying that we should provide competent and diligent representation, and 1.03, giving enough information to a client so that they can make a reasonably informed decision. So we'll discuss that a little bit more in a moment, but I want to touch briefly on 1.02C, which prohibits lawyers from counseling clients to assist in criminal or fraudulent behavior. And I want to reiterate that that rule, because sometimes pro bono attorneys might be reluctant to advise a client to stay in the US for fear of encroaching that rule. However, I want to make sure everybody understands and knows that overstaying a visa is neither criminal nor fraudulent. So do not worry about that. And although an entry without inspection can be a misdemeanor, once it has occurred, it is not a continuing criminal violation to remain in the US. So with that said, of course, competent and diligent representation will mean you need to be competent in the communication. So competent translation is critical for our clients with whom we have language barriers. It's important to keep in mind cultural differences, because certain behaviors, as you may know, may be acceptable in one culture, but not the other. So be aware of those differences and be culturally humble. And let's not minimize trauma. Trauma is a very real thing, and working with survivors of trauma, including survivors of sexual assault, requires special consideration to avoid re-traumatizing the victim. So we need to be very careful and gentle about that.
So we won't have time to focus more on trauma, but as Catherine just mentioned, we want to make sure that with the work we do, we focus heavily on trauma-informed lawyering, and it's a partnership with our clients. Again, you're building rapport, you're working with the client in collaboration throughout their case. You have to gain their trust. It needs to be an open-ended relationship where there's a free flow of information. If they trust you and they believe that they can rely on you, they're much more willing to cooperate with you, and it makes your job so much easier. All right, so now we can close out just talking to you a little bit about getting involved with HRI, which is hopefully why you're here. So we talked about the onboarding process and how we're going to be working moving forward. There will be a newsletter that if you all are interested in, we can get you signed up for, where we will basically send out a blast expressing cases that are available for placement. That will be coming from our legal director, Richard Lucero, from a pro bono email that I will share shortly. And then there you can express interest, again, saying if there's a particular case, facts that pique your interest that you want to get involved with, feel free to reply to that. With that partnership, as Catherine mentioned earlier, you get samples, templates, guidance all the way through. We have what we call a mentoring model. So we are guiding you every step of the way because we understand this is not your main practice area, although many may be litigators or handle transactional work regularly. We want to make sure that you feel supported all the way through. And this, without further ado, is that QR code that Alex mentioned. I also did drop the link in the chat. So hopefully that got shared, or if not, if we can reshare with more participants.
And the CLE course code is also in the chat for anybody that wants to claim CLE credit for today. Please self-report with the State Bar for today's presentation. Thank you very much, Catherine and Evelina. Really appreciate the time today. I hope it's been informative to everybody in attendance and that people are inspired to help join the good work that HRI is doing. Really appreciate your time today. Thanks, everybody.
And thank you so much for joining us. We appreciate the time.
Thank you.